Get ready. Start.
The material available in this case is sufficient to hold that the impugned notices suffer from arbitrariness and non application of mind. They are violative of Article 14 of the Constitution, hence, they are liable to be quashed. It is not necessary, therefore, to express any opinion on the contentions based on Article 19 1a of the Constitution. The rest of the questions relate truly to the civil rights of the parties flowing from the lease deed. Those questions cannot be effectively disposed of in this petition under Article 32 of the Constitution. The questions arising out of the lease, such as whether there has been breach of the covenants under the lease, whether the lease can be forfeited, whether relief against forfeiture can be granted, etc., are foreign to the scope of Article 32 of the Constitution. They cannot be decided just on affidavits. These are matters which should be tried in regular civil proceedings. One should remember that the property belongs to the Union of India and the rights in it cannot be bartered away in accordance with the sweet will of an officer or a minister or a lieutenant governor, but they should be dealt with in accordance with law. At the same time, a person who has acquired rights in such property cannot also be deprived of them except in accordance with law. In this case, are very high for both the parties, and neither of them can take law into his own hands. I therefore quash the impugned notices and direct the respondents not to take any further action against the petitioners pursuant to them. I express no opinion on the rights of the parties under the lease and all other questions argued in this case. They are left open to be decided in an appropriate proceeding. It is, however, open to both the parties, if they are so advised, to take such fresh action as may be open to them in law on the basis of all the relevant facts, including those which existed before the impugned notice dated March 10, 1980 was issued by the engineer officer of the Land and Development Office to vindicate their respective rights in accordance with law. This order is made without prejudice to the right of the Union government to compound the breaches, if any, committed by the lessee as such in the case. I have perused the judgment prepared by Brother Justice A.P. Sen, as also the judgment of Brother Justice E.S. Venkatramaya. While I agree that the impugned notices threatening re entry and demolition of the construction are invalid and have no legal value and must be quashed for reasons detailed in the two judgments, which I do not propose to repeat over again. I am of the view that the other questions involved in the case are based upon contractual obligations between the parties. These questions can be satisfactorily and effectively dealt with in a properly instituted proceeding or suit, and not by a writ petition on the basis of affidavits, which are so discrepant and contradictory in this case. The right to the land and to construct buildings thereon for running a business is not derived from Article 19 1a of the Constitution, but springs from the terms of contract between the parties regulated by other laws governing the subject, viz. the Delhi Development Act 1957. The master plan, the zonal development plan framed under the Delhi Municipal Corporation Act and the Delhi Municipal Bylaws 1959, irrespective of the purpose for which the buildings are constructed, whether there has been a breach of the contract of lease or whether there has been a breach of the other statute regulating the construction of buildings are the questions which can be properly decided by taking detailed evidence involving examination and cross examination of witnesses. I accordingly allow the writ petitions with costs against the Union government and the Lieutenant Governor of Delhi and quash the impugned notices. As per the decision of the Supreme Court, the UOI could file a civil suit, which then led to the filing of the present suit by the UOI and thereafter a counter suit by express newspapers. A so cause notice was issued on 1st August 1986 by the Ministry of Urban Development after the decision of the Supreme Court. The said notice was based on the premise that Justice Sen's opinion in the Supreme Court's decision was a minority view. Paragraph 12 of the so cause notice reads as under: the writ petitions were heard by a bench of three honorable judges of the Supreme Court, consisting of Honorable Mr. Justice A.P. Sen, Honorable Mr. Justice E.S. Venkataramaya, and Honorable Mr. Justice R.B. Misra. Their Lordships Honorable Mr. Justice E.S. Venkataramaya and Honorable Mr. Justice R.P. Misra held that notices dated 1/3/1980 and 10/3/1980 were invalid on the ground that the said notices were arbitrary and for non application of mind in the present case as such. Stop.